classes, and college application fees, all of that. What are all of those basically fixed college expenses? But beyond those basic expenses, there's also, a lot of discretionary spending that the kids have. For example, car payments, car insurance, car maintenance and repairs, car registration, AAA costs. What are their cell phones? What is their health insurance? Who's paying for it? What are their unreimbursed health expenses? And are there funds available for that? What is their rent if they're living off campus? What are the renter's insurance and utilities and all of that? Let's quantify all of that for where each child's going to school. And then beyond those sort of expenses, there's even more discretionary expenses like dorm supplies, household supplies that they're living in an apartment, toiletries and restaurants and groceries. Ask what kind of expenses are these kids incurring? What are their clothing expenses? Do they go to Starbucks? Do they get their hair and nails done at school? Do they go to movies? Do they order things from Amazon? How often do they do that? Do they take Ubers? How much is that going to need to be? What is their gas money? What is their spending money? And all of that, you really need to go through and ask the parents to identify what they think these expenses are. And then I try to see if we can come to a number on those really discretionary expenses and say, okay, I think each child needs to have $500 a month, whatever the number is for that particular family, once they go through and say what they're spending on these expenses, so that we can figure out, how do you share them? How do you pay those expenses? For instance, are the kids going to work? Are they going to pay some of the expenses? If not, maybe one parent pays the rent and the other pays the car insurance and car payment. Maybe that's sort of equalized or in the right percentage. You can offset those types of expenses, but then maybe see if they can come to an amount of money for these other discretionary expenses, spending money and the like, so that they can fund that in some way on a 40-60 basis or a 50-50 basis, or whatever basis that is. Not only do you have to figure out how to share those expenses, but the other piece of it is, how are you going to fund it? Are you going to give the children money every month? Are you going to fund a bank account? Are you going to, how else do you think that your kids can fund these expenses? If student loans need to be taken, which parent can afford to take them? Which parent can qualify for the loan? Will the kids be obligated to pay it back, and the parents are only now asking qualifying to take the loan? Are the parents going to share in repayment? All of those are questions that need to be looked at, because the FAFSA loans are loans that the children can take in their own names. But if the college expenses exceed the ability and the income of the parents to pay on an ongoing basis, sometimes you have to look at student loans and how they can be qualified for. What else can we talk about? I have a case, and the reason why I have all of these discretionary expenses that I've sort of gone through for you is that I had a case where I had the parents who we went through and we identified the college tuition, the books, all of the car payments, all of the spending money, etc. And we had the kids' budgets. And then we looked at each of the parents' spending plans. And then we looked at their net income. And they simply couldn't pay it. They were convinced that they could each live their lives and pay their pet expenses and fund the children's expenses that they decided would be a level of expenses. And I said, you just really can't do this. It's just not possible when you run the numbers. So I find it really helpful to make sure that you focus clients on the actual expenses, what they think they're going to be paying, and how that compares to their needs and their actual net incomes. Bruce, I think for my piece, for that part of it, I think I got to give it back to you to start to address our next topic, which is the premarital agreements. Oh, you're muted. You're muted.
You think I would be smarter than that if I'm running this thing?
We never get good at that.
So I wanted to mention, and it wasn't on the recording because I messed up recording until a couple of minutes in, but you said something in the beginning that really struck me, and I've never really asked people that question before, is what's your litigation budget? I think that's brilliant. I mean, we often ask people, like, what's it going to cost you to continue to litigate something if they're in the middle of litigation or something? But I think it's a wonderful question to ask for those who are potentially watching this. That was one of the first things you mentioned.
Yeah.
The other thing I think is interesting that I tend to do when I'm mediating college issues is to suggest to people that they might consult with a college financial planner so that they can understand that interplay between what they're doing and financial aid issues. Because oftentimes, the parent with the lower amount of income that they show on their tax returns can have better success when they're filling out FAFSA forms and things like that. So I just think it's something that people should keep it on top of and understand how that's going to play in the overall scheme of their financial ability to, pay for college and things like that.
And then one other piece, Bruce, just to finish it up on college support, college expenses and child support, is you also want to consider what's going to happen in the summertime, who they're going to be living with, and how you're going to pay those expenses in the summertime as well. It's sort of a whole nother piece, but it's definitely something that needs to be addressed on top of the actual college semester.
And is the child going to be required to get a job and work and pay and earn some income to help defray some of those costs going forward? So lots to think about.
There's also apps out there that are helpful for children and parents to help them to apply for as much free money, grants and scholarships and the like. Their high schools can provide them with information on that. And the colleges even can provide information on that so that they can start applying early for as much free money as they can get.
That's great to know. All right, we're going to move into the next area, which is premarital, mediating premarital agreements. So I've done a few of these. I don't know how many other people have. My experience with doing these kind of agreements has been that they are tricky and they are difficult in a different way than mediating other types of situations. Fundamentally, one of the reasons is because there's a lot of other things at stake in mediating a premarital agreement than mediating other types of family law issues. Other types of family law issues, the end result, if you don't resolve things, is potentially you have a judge making a decision after a litigation. That's not an option in premarital agreements. The end result, often, if the mediation fails and the people can't come to terms in terms of signing a premarital agreement, the end result may be no marriage. And that's complicated for a lot of people. And this sort of like highlights the interplay and the conflict between love, romance, and money. And so, that can be really complicated. The other issue I think that comes up in premarital agreement mediation often is also the fact that many times it's not one or both of the participants or the soon-to-be spouses, the bride and groom or bride and groom and groom, whatever, it's their family. It's often it's family money that's at stake. And so it's a parent or somebody else who's really pushing the issue and wants the premarital agreement to be signed. So now you've got this added dynamic of other family members who are sort of driving the bus and potentially creating issues and sometimes disagreement and sometimes some anxiety and stress. I mediated one about a year or so ago where the client that I was representing did not want the premarital agreement, but his father was insistent because it was all family money and there was a lot of money, family money at stake. I also did one a few years ago where it was the same kind of thing, but it was the husband, the groom, the husband to be was asking for the premarital agreement. And he basically took a position of, I'm here because I was asked to be here, but there's nothing to mediate. You either sign it or we're not getting married. And we mediated 3 or 4 sessions of trying to figure out ways to tweak things that would help her feel more comfortable about signing this agreement. But basically he was just sort of saying, it is what it is, take it or leave it. So it was a very interesting situation where he seemed to be very much okay with the possibility of them not getting married. So
Sort of telling Bruce, maybe that's how the marriage might go. Would have been a good eye opener.
So but it is very interesting because you have so many different of those kind of dynamics that go into this kind of thing. But if you are going to mediate these types of situations, one of the most important things I think that you need to have is some basic knowledge of the law. The statute that governs the contents of a premarital agreement is NJSA 37:2-34. It very specifically tells us what we can put into a premarital agreement. Generally, the rights and obligations of the people financially between them in relation to what would happen if they get divorced, or what would happen if they if one of them dies, in relation to not just support issues, but also distribution of assets, allocation of debts, those kind of things. But what can't go into a premarital agreement and is not enforceable are custody and parenting provisions, and generally child support provisions. Child support provisions are kind of iffy because you can certainly put something in there and it might be upheld if it's still found to be reasonable and conscionable at the time of the divorce. But the law still gives the court the ability to avoid what was put into a premarital agreement if the court finds that that's in the best interest of the children, even when you're talking about things like child support, college contributions, and those kind of things. So it's really important to know what you can and can't do, what you should and shouldn't put into a premarital agreement. So it's good to have a basic knowledge of that statute. I actually have at times shown my clients that statute and says, here's what you can do and here's what you can't do. You should also have a good basic knowledge of the enforcement statute. The enforcement statute is NJSA 37:2-38. And that talks about what needs to be in the agreement to make it enforceable. One of the main provisions there is disclosure. There has to be full disclosure. So it's one of the most important things. Whereas people can get divorced and people can make decisions on family law issues in all kinds of areas without disclosure if they agree to waive disclosure. Premarital agreements, there really has to be disclosure. I'm not sure even a waiver of disclosure is going to suffice with a premarital agreement. And then one of the other major provisions there is timing. And so you really need to look at the timing of this mediation and how far in advance of the wedding is it? Are you giving yourself enough time to really work with this couple and get them to a place that they're comfortable signing an agreement far enough in advance of a wedding where it doesn't feel like one of them or both of them is pressured into signing it just because the wedding is 3 days away? Historically, we used to get these calls, 2-3 weeks in advance, like, I'm getting married in a month and we need to have a premarital agreement drafted and signed. And, that really doesn't fly. If you take a really, a really hard look at the statute, it may not fly. So it's really important to have that timing down. While attorneys are not necessary, they're not required. It's a really good idea because it helps to show the independent voluntariness of the agreement, that people have consulted with lawyers, that they've gotten the advice of lawyers and things like that. But again, in the statute, it talks about consulting with independent legal counsel and voluntarily expressly waiving the right to counsel. And I also think that it's a really important concept where you have potentially a little, and often in these kind of situations, you really do have an imbalance of power because you typically have one person who's got the money in their family, or they have the money themselves and they're pushing this. And the other person often feels like they kind of have no choice because if they want to get married, they got to sign the agreement. So when you have that imbalance, it's a good idea to have, at least to have lawyers involved. It sort of just gives it an added aspect of protection. When you're mediating a premarital agreement, it's just like mediate it step by step, issue by issue, talk through them, try to get everybody to a resolution, sort of building blocks. Sometimes you have to set some issues aside to try to resolve things that are resolvable before you get to the really tough ones. And then lastly, before I turn this back over, I think actually I'm turning this back over to you. One of the most important takeaways of this, I know that a lot of people will draft marital settlement agreements as a mediator. Do not draft a premarital agreement. Just do not do it. I think that could potentially be a significant issue in terms of enforceability in the future. I don't see any case law on it. There's nothing in the statute about it. It's my sense. And my sense is there needs to be that separation between the mediation and what was agreed on and discussed in the mediation and what actually is put into that agreement and how it's executed. So important if that agreement's going to be enforceable in the future. All right, Megan, you're going to talk. Oh, sorry.
Let me ask you a question. So,
sure.
Often the premarital agreements are the result of one spouses to be parents wanting it. Would you ever bring the parent in to a mediation involving to get his or her input or to help facilitate a conversation?
I've never been asked to. That's an interesting question, because I take the position normally that I'm willing to involve anybody in a mediation as long as everybody agrees to, if it's going to help move it forward, if it's going to help everybody get to a resolution. That's when I really have to think about carefully, because boy, does that add a dynamic into the room that could be really difficult. But if everybody is on board with, we want to do this, this is really what we want, and we think that bringing in, dad to participate in this would be helpful, and everybody agrees to it, I might say yes. I think I also want to make sure that I'm looking at that imbalance of power and how comfortable the non-moneyed potential spouse is in doing this. So yeah, that's a complicated question, but it's a good one. All right, you ready to go on to your next topic?
Yep. Okay, so moving along. The next topic is modification of alimony. So this is generally, obviously, a post-judgment of divorce issue that comes up. And again, as I said initially, with the college and child support expenses issues, I always ask why you're here, why you're in mediation. And if it's an alimony modification because there's a loss of job or a retirement or a disability, why are you here in mediation? And again, just to get buy-in. And the second question, again, the same question is, what's your budget for litigation if you don't resolve them here? Like, how much do you have set aside to work this out? And I find, again, that most of the time there isn't money set aside for this at all. And that I like to keep reminding them of that when we hit rough patches in mediation. So the statute that the 2014 alimony amendments, there have not been a lot of cases associated or case law associated with those alimony amendments. So we're kind of on our own in terms of, again, asking as many questions as possible to help folks come to an agreement on these issues. I find that it always amazes me when I feel like, oh my gosh, this is so difficult. I'll never be able to help them come to an answer or to a resolution. But I just keep asking questions, and amazingly, with the more questions and just the more answers, they end up coming to a result on their own. And it reminds me that I'm not there to make decisions or to fix this for them. I'm just there to answer questions, ask questions, and help them answer the questions. Okay, so what is the reason they're coming in for an alimony modification? Did they retire? Did they retire at full Social Security age, retirement age? And did they stop working? Or are they coming in earlier? And if so, why? What is their reason? Is the pay or spouse asking for some accommodation because he or she wants to retire early? And then the payee spouse that asks questions around that. Well, did you ever have conversations about maybe stopping work early? What is your work situation now? What is your income situation now? What is your financial situation now? The payee could have inherited money subsequent to the divorce. There's a lot of different changes in circumstance that could have happened. So the more questions I find that I ask in these retirement situations around what the current financial situation is, what has happened since the divorce, what assets have been accumulated or not, what employment has been obtained or not. And then if this is a different than retirement and it's more a loss of employment, is there a reason? Was there a loss of employment, let's say for insubordination or something like that for a cause, and the payor has not become reemployed? Questions around what efforts are being made so that there's full disclosure. I think both sides, when they're making decisions on these types of things, need as much information as possible. And as the neutral facilitator, I find my role is to help them ask those questions and get all of the information they can possibly have so they can make informed decisions. So if somebody loses that employment, for example, like that, or the industry changes, like for example the mortgage industry was hot for so long during COVID, and then the mortgage industry has completely, very much so quieted down, and the incomes are therefore calming down, and so is that a basis for a modification? I mean, they're here in mediation to try to resolve it, right? So it's not our job to decide whether there's a legal basis. It's, well, what is your income now? What are your expenses now? What do you plan? What do you think you can rebuild the practice to? How long might it take? Can you look at things in incremental steps? Can there be a temporary modification with the idea to give it time? In mediation, we don't have to make anything permanent. We could say, maybe let's talk about a modification now while this person's looking for reemployment. Maybe it's some modification. Maybe that payor is still using cash or other assets that employer that payor spouse has in order to supplement what would have otherwise been the obligation. Is the reduction temporary? A lot of times the reductions are temporary. But for instance, I had a case where the payor was in an industry for many years and had a pretty consistent salary over those years, and all of a sudden the company closed and he was out of a job, and he was in his mid 50s. And so one of the questions you have to ask is, how old are these people that are having these issues? How likely is someone at that age to be able to get the same job or a similar job at the same level of income? In this particular case, the gentleman had decided he wasn't going to be able to get a similar position at a similar rate of pay, and so he decided what he wanted to do was start his own. He was going to buy a franchise and start the franchise. That franchise required an initial buy-in amount, and it was going to take time to build up that business. But we could ask questions around all of that and how much time, what was the basic initial income, what were the planned proposals for increases in income. And you can talk to spouses or former spouses about having incremental modifications or having incremental sharing of income information so that there is complete transparency around giving a spouse who has had a loss of employment at no fault of his or her own, be able to continue to provide some support, or at least be given the ability to step back and establish a new business in good faith, and still have some type of a support obligation. So again, it's about the questions that I ask of them, and the information that each spouse wants from the other. Like, well, okay, what did the franchise agreement look like? How much are you getting paid from the franchise agreement? What are the estimates that franchise agreement has given in terms of cash flow, et cetera? And the more exchange of that information, the more we have to work with in terms of figuring out how to accommodate some type of a modification. That's about what I have on this piece, Bruce. Any other thoughts that you have?
Yeah, a couple of them. So I think that two of the hardest areas that we deal with regard to modification of alimony are cohabitation. That because the law is just so wide open on this cohabitation issue now. And the second is when you have the over 55 person who got laid off. downsized, something happened, the company went under, whatever. Because this is one of those areas where you really start to have the tension between the law and reality. You know, the law says it's going to work on use somebody's earning capacity and what's their earning capacity. But the reality is it's hard for somebody over 55 who is making, you know, good money, 6 figures, maybe more than that, to get a job at that age, because most, you know, unless companies really are looking for somebody with that specific level of experience, you know, if they can hire somebody 10 or 15 years younger for a lot less money, they're going to do that. That's the reality of the unfortunate age discrimination that, you know, there is in the workforce. That it's just, again, I just think that's just the reality of the situation. And there's so much speculation about, well, what can somebody really make going forward? Can they duplicate that $350,000 income that they had for the last 20 years or so, or that they built to $350,000 over the last 20 or 25 years? And my experience of late has been people are having a much harder time finding employment that is comparable in pay scale to what they had. And it's complicated because there's a lot of suffering that goes on financially for people. So I'm gonna.
There's. Go ahead. Do you have a code? You want to give a code?
No. I was gonna just answer one of these questions about this topic since we have a few extra minutes. But go ahead. What did you want to say?
No, that was what I was going to do. There's a question on the topic of the question for a topic of revising alimony. Would inheritance be relevant to either the payor or payee? I thought that would be outside the boundaries in a post-divorce situation. And, you know, it may be if you're talking to a judge and the judge is making a decision, but if you have folks in mediation that are in mediation because they want to resolve it, it might be, I mean, I think it is a relevant question. It doesn't mean it's dispositive of anything, but I think the more information both folks have, the easier it'll be to come to some sort of an agreement. That would be my thought.
If somebody has an inheritance that's significant enough, their financial circumstances have to be taken into consideration. But I think it has to have been an already inheritance. Like we get these people who say all the time, well, you know, she's going to inherit $1 million when her mom dies, or he's going to inherit, you know, X amount of dollars when somebody dies. You can't deal with what may happen in the future, even though it seems pretty obvious that it's going to happen. You can only deal with what's already happened. But absolutely, I agree. Inheritance is an issue because that changes that person's financial outlook and their current circumstances, sometimes dramatically. All right, let's go on. I'm going to give the code. If I could find it, because I wrote it down and now I can't find it. The code for today's program is CC for Carl Cangelosi, WS for webinar series 24. So it's CCWS 24. I'll do it again at the end, if Megan, if you remind me.
Okay.
I'm going to talk about another subject that I think is really interesting, and I'm starting to get a few more of these of late, and they are mid-marriage and reconciliation agreements. These are not often typical. I think they're kind of unusual, but I've started to see these more and more lately, and it's very interesting. So the first thing about these, there's a difference between a mid-marriage agreement and a reconciliation agreement. A reconciliation agreement starts with the fact that the people are on the verge of divorce. They are either separated or somebody's filed a complaint for divorce. There's some litigation going on between them, or there's some formal, you know, thing that's happened that indicates that they are headed toward divorce and they want to reconcile. That's a reconciliation agreement. A mid-marriage agreement is two people who are maybe contemplating divorce, still living together, and they want to see if they could find a way to salvage the marriage and come to some kind of an agreement. And there's actually case law on these. That's important that I think if you're going to do any of these kind of mediations, that you read the case law. It's not complicated case law. It's not a lot of legal language. They're pretty straightforward. The first one is called Nicholson versus Nicholson at 199 NJ Super 525. 199 NJ Super 525. It's an appellate division case, believe it or not, from 1985. I was at college. That's really the case that talks about reconciliation agreements. And it basically says that in some circumstances, a reconciliation agreement can be enforceable, but there needs to be consideration. There needs to be a reconciliation as a consideration. And they analogize that to the premarital agreements. In a premarital agreement, the consideration is the marriage, is the wedding. In a reconciliation agreement, the consideration is an actual reconciliation. So they really, differentiate between, without having really talked about mid-marriage agreements, it really differentiates between the two. Because in Nicholson, they were separated, and they wanted to reconcile. The other case is called Pacelli, Pacelli versus Pacelli, 319 NJ Super 185, and that's an appellate division from 1999. And that's where the court really differentiated between a mid-marriage agreement and a reconciliation agreement. And in that particular case, the parties were not separated. They were still living together. The court found they weren't actually even on the verge of divorce. So there was no actual reconciliation there was no actually consideration for the agreement. And what the court said there was that there wasn't a showing that the marital relationship had genuinely deteriorated, and that the husband's primary interest in executing the agreement was financial. Court also found that the terms of the agreement were not fair and just. So kind of like on this unconscionable level, the court found that the agreement may not have been conscionable, and gave all kinds of reasons why it was unconscionable and what happened between the parties entering that agreement and somebody trying to enforce it. I guess in that particular case, the husband was trying to enforce it. So when you have people who come in, I think the first thing you need to establish is, what are we really doing here? What are we actually mediating? Are we mediating a mid-marriage agreement, or are we mediating a reconciliation agreement? And be very careful. And I would suggest that you use the statute about premarital agreements as somewhat of a guide in mediating these, in terms of what can you put into these agreements and what you can't. You still should not put custody and parenting issues in. I just read one recently where the language in this agreement said that if certain things happen and these people separate and they get divorced, husband waives his parental rights to their daughter. That's never going to fly. It's never going to be enforceable. And part of the issue in that situation was, I was actually representing this person. It wasn't a mediation, but I was arguing that it wasn't even a reconciliation agreement, so it was unenforceable and unconscionable. And one of the ways I was going to argue, if we had litigated it ultimately, that it was unconscionable, was using the fact that there were provisions in that agreement that were completely unenforceable by a court, like this custody and parenting issue and other things. So I think it's part of this is sort of giving our clients this understanding in mediation that we can mediate these issues, but if you include too much and you include things that really are not enforceable, you run the risk that those issues might cloud the other ones and might make it unenforceable ultimately. And I think that's part of the sort of like the educational process sometimes about working with clients in these kind of situations. I also want to just briefly mention that, and again, by the way, the part of the issue with this is sometimes the stakes are quite high, because again, you're not just looking at the possibility of litigation over divorce or some breakup or something like that, you're looking at the fact that these people don't really want to do that. They don't want to go in that direction. They want to reconcile. They want to keep their marriage together. So, you know, the stakes are that if you're not successful in the mediation and helping them get to a resolution, they might end up getting divorced. And that sort of, to me, ups the emotional stake in the mediation. So there's one more area that I wanted to just briefly mention, which is a new area that's emerging. I think Ken Newman is doing some of this. It's called discernment mediation, where you have a couple who might be in couples counseling, marriage counseling, and they're trying to decide whether they should divorce. And they go to a mediator to help them sort of work through that issue. I'll be very frank with everybody. I'm not sure I really understand why people are going to mediation to do that as opposed to couples counseling to do that. But I've heard this from a few other people who have started to embark in that kind of area. I'm going to actually tap into Ken Newman next year and see if he wants to do a whole webinar on it. I know that Carl Vinier is also looking into doing that kind of mediation. And it's basically for people who are experiencing problems in the relationship and using our mediation techniques to help resolve disputes in their relationship, to work toward a reconciliation and moving forward instead of moving in the other direction toward divorce. But what I've read about it is that it can also help people sort of get to that decision-making conclusion of, should we divorce or shouldn't we divorce? And I thought about this as I was preparing for the webinar, that, you know, it might be that this is an opportunity to have people look at what would it look like to get divorced, which I don't know that in couples counseling they could really do, but what would it legally look like? What would it financially look like to get divorced? And maybe if you map all that out for people sometimes, maybe they decide, oh, it's not worth it. I don't want to get divorced. I'd rather figure out a way to work on our marriage and stay married. Or as someone recently said to me, or maybe they decide to live separately and together in various ways, but they don't actually get divorced. So it's a really interesting concept. So here's what Megan, you want to add anything to that?
Yeah, no, I think that's a great point, though. And again, I think it's people needing to ask questions, just needing a forum with a neutral person. And if they're getting some information, starting to talk about finances in the event of a divorce, a lot of people, by the time they get divorced, are so far into it that they can't back off of it and say, okay, we'll stay together. But if they were to do this sort of before they're ready to kill each other and just get a sense for what it's really going to look like, it may incentivize them to get some counseling and stick with it. And it's just an option.
Yeah. All right, so I'm going to do a very brief, I'm going to try to do this in 5 minutes. I talk about school choice. And the reason I picked this topic, quite frankly, is I have done a lot of these. And I'm somewhat fascinated by the number of cases I actually have mediated, because the reality of mediating school choice, where are the children going to go to school when parents live in different school districts? The reality of that is there isn't a compromise usually. One person is going to ultimately win this battle. The kids are either going to go to school in one parent's district or the other parent's district. They can't go to school in both. And because of the way our school districts lie, there's no in between unless they choose like a private school or something like that, which obviously has some financial issues to it. But I also just mediated a different aspect, and that was one parent wanted to homeschool the children and the other parent wanted the kids in public school. You know, these are really complicated issues to mediate, because you have people who have incredibly strong fundamental values at stake in these decisions. You know, they're typically not people who are deciding between a really, really poor school district and a really, really good school district. They're usually trying to decide between two similarly situated school districts. Sometimes it's one is, you know, slightly better or a lot better than the other, but the other one isn't a bad school district. It's just not as good as the other. I think these are incredibly hard cases to mediate because of the fact that there's just not a lot of compromise available to people. So the way that I approach it with people is we talk about logistics, we talk about distance, driving kids back and forth, things like that. We try to work through it to see, what's going to work best for people. And I'll share with you one that I had at some point, which I always find so fascinating to me. It was these two people lived in southern Gloucester County, which is about 45 minutes to an hour south of Camden, New Jersey, and Philadelphia. And they both worked in the school district where their kids went to school. But then mom moved to Burlington County, which was about 45 minutes away, but was still working in the school district in Gloucester County. And for a variety of reasons, many of which were really legitimate reasons, she was insistent that the kids needed to go to school in Marlton, New Jersey, not in Gloucester County. There were some bullying issues. There were some issues because a lot of people in the district, teachers, parents, administrators, and students, knew too many of the intimate details of the divorce of these people. There had been a long time relationship between the husband and a coworker. I mean, there were so many issues that evolved. But logistically, it made absolutely no sense for these kids to go from Gloucester County to Marlton when they were with their dad 50% of the time, because somebody had to drive. It was crazy. But when mom had the kids, she could drive them from Marlton to their school in Gloucester County. I mean, it just logistically, it made so much sense, but we could not, we mediated. I think I met with them like 3 times, and we mediated and we talked about every virtual possibility. We talked about private school. We talked so many different things. And unfortunately, we didn't get it resolved, and I have no idea what happened when they went to court on these issues. I suspect that the kids ended up staying in their schools in Gloucester County. But we really spent a lot of time. I sent them home. One of the things I ask people to do in these situations is write it down. Give me a list of things that would need to happen in order for you to agree for the kids to go to school in the other parent's district. Like, what are all the things that would have to happen? I mean, let's explore them. Are they possible? Is it possible to get you everything you want that would allow you to agree? And I think that that's one of the best ways to sort of address this issue, since there really isn't a compromise. All right, Megan, do you have anything you want to add before we go on to questions?
No, I think we can go on to some questions. There was some.
Okay.
Yeah.
Let's start with the first one. The first one was this is really for you because it's about college. How far can one parent go when discussing how far can you go when discussing the children's obligations, such as applying for student loans or scholarships prior to a parent's obligations kicking in? And what if the child refuses?
Yeah, I mean, that's always the possibility, right? So even if you're doing in a situation where each parent decides that they will guarantee a certain amount of student loans with the agreement between parents that the kid is the one to be paying it back, the reality is the parents are the ones on the hook. And if the kid says no, or doesn't graduate, or whatever other options we've all seen happens, then the parents each need to know they're going to be the ones holding the bag for that. So it's really important that they not just go into these things lightly and, thinking, oh, I'm just going to secure the loan, and they're really going to be paying it back, because they could really end up on the hook for it. Yeah.
So the other part of that is that the parents are only agreeing what their obligations are as between them. So I think parents can agree to anything. We have really yet to see any kind of real heavy duty litigation that's brought us any kind of good solid case law on kids taking actions themselves against their parents. But I think parents can go as far as they want to go in how much they're going to require their kids to contribute. I've mediated cases where parents have said to me, we're not contributing anything. We went to college, we paid for college on our own, we paid our student loans, we expect the same from our kids. And that's what they put in their agreement. How enforceable that is going to be in the future, nobody really knows. But keep in mind, the marital settlement agreement is only between the parents. So and even a post-judgment agreement, a post-divorce agreement on college is only between the parents. I think the answer to my answer to your question, Glenn, is they can go as far as they want. If the child refuses, well, they have to figure out another way to fund their college education aside from how much their parents are going to contribute. I think it's really kind of that simple sometimes. Suzanne gave us a whole bunch of information about FAFSA. Thank you, Suzanne. I think that's in the Q&A, so I'm hoping everybody can see it. But if you can't see it, maybe, Suzanne, you can cut and paste it into the chat. But you're basically saying that FAFSA treats married and divorced people's parents differently. Eric Friedman, who also has his hand raised. So Eric, do you want to speak also? You mentioned that Ken is a unique example of what we were talking about because he's a clinical psychologist. So he's more than halfway there in sort of his training and counseling. Trying to see cohabitation agreements. Wow. You know what, Adam? I think that's I wasn't prepared to address it, but I think it's a great subject that I'm going to put on my list as possibly something that we could talk about in a future webinar. Because to be frank with you, in the answer to that question, I'm not sure that cohabitation agreements are enforceable in New Jersey, because I'm not sure what the consideration would be for the sort of cohabitation other than living together, and I don't know that that would be sufficient. So I'd have to really look that up. All right, Eric, I'm giving you talking ability. If you have something else you want to ask or add, I just
You're
gave you the
muted,
ability.
Go ahead.
No, Bruce, I just wanted to point out that in that notation, Ken, just knowing Ken the way I do, certainly anything he seems to do is certainly unique, to say the least, without going into it. And I've enjoyed all kinds of stuff in dealing with Ken. But when you have this sort of blurred line, obviously, between in mediation, I always get a kick out of talking to mediators and seeing, they're a mediator, but their background is this. I've yet to meet somebody that's like 25. And I'm 59. And so it's a business background, it's a legal background, it's a psychological background. So all of these things color that approach. So when you mention that with Ken, although it seems sort of out of left field, my statement was, hey, it's given his background. It makes sense. And it seems like a logical extension of his, even a muted extension, I would say, of his skill set on the whole. That's all.
All right. Thank you. I got Anna Maria Patella. I just brought you in to be able to speak if you have a question or a comment.
I did not have a comment or a question. I think you guys
your
are doing
hand.
great. Plow on, plow on.
Your hand was raised, so I called on you.
Maybe it was my mouse that did a circle there.
Gotcha.
Sorry about that.
All right, thank you. All right, and the next is, oops, wait a minute, hold on, Anna Maria, I just think I messed up there. Okay, there we go. And the next is Anju. Your hand was raised, so you now can speak if you unmute yourself.
You can hear me?
I can.
So I actually got excited with the topic of a cohabitation agreement. There's nothing to say it isn't enforceable. It's an agreement by two people. who, if they have sound mind, can make an agreement. So I'm thinking that I'm going to add that to my services, right? Just like roommates can have a roommate agreement. If you watch whatever it is, The Big Bang Theory. Yeah, I think that's something to explore. Why wouldn't it be enforceable so long as it was reasonable, it wasn't unconscionable? But that's my comment. I'm excited. It's a new area.
So Anju, I guess my answer to that is sort of like in that mid-marriage agreement case that I think to myself, well, why wouldn't a mid-marriage agreement be? This married couple decided to enter into an agreement voluntarily. They agreed on all of this stuff. Why isn't that enforceable? But the appellate division said it's not for a whole bunch of different reasons. So that's why I don't want to tackle too much here because I don't know enough about it yet. But I put it on my list of potential topics for next year for a webinar.
Thank you.
Okay, thank you. I appreciate it. Okay, it's 12:58. I'm going to read the code again. So today's CLE code is CCWS24. Again, it's CC for Carl Cangelosi, WS for webinar series, and 24, which is the year. I don't think there's any other questions in talk about a post-nuptial agreement.
Yeah, Linda Spiegel brought up, talk about a post-nuptial agreement when the parties were negotiating a premarital agreement, but didn't have time to finalize the agreement versus a post-nuptial agreement without prior negotiations.
So my answer, it's so funny that you're asking that because I actually had a client at one point who, you know, they were trying to rush to get an agreement done. They couldn't get it done. They ended up agreeing that they would do an agreement after the wedding. And my advice to my client was sign whatever you want. But if I understand New Jersey law correctly, you can sign anything you want after you're married. It's not going to be enforceable. And I still don't think, even if you started it before the marriage, if you sign it after the wedding, I still think it will count as a mid-marriage agreement. And I think as of right now, under the Pacelli case, it's not going to be enforceable. But again, until somebody brings another one of these to the appellate division of the Supreme Court of New Jersey, we don't know how it's going to fall in terms of enforceability. So it's an interesting wrinkle on it, quite frankly. And again, in that case, Linda, that I was telling you about, it was the husband's family that was pushing it. It was they wanted the prenuptial agreement. He didn't really care too much, but his family wanted it. There was a lot of family. There's actually a lot of family money on both sides of that situation. So I'm interested to see if it ever plays itself out. And I guess eventually we will probably have some case law on stuff like this, because I think more and more people are doing these, excuse me, are doing these kind of things and maybe crossing their fingers and hoping that they're going to be enforceable in the end. All right, so in honor and memory of our dear Carl Cangelosi, it's 1 o'clock and we're going to end right now because we go 12 to 1, not a minute after. So thank you all for participating today. Megan, thanks so much for joining me today. I really got a lot out of what you had to say and appreciate it. Everybody have a wonderful summer and keep an eye out for our series starting again in September. And please, 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 if you have any interest in presenting or you have some topics that you want to see us present next year, please send me an email and have a good day.
Thanks, Bruce. Be well.
Thank you.
Okay, bye-bye.